Good morning, members. We're from quorum. I now call the meeting to order. First, we need to confirm the minutes. It's the minutes for the meeting held on the 16th of December 2014. The Secretariat hasn't received any proposed amendments. May I take it that the minutes can be confirmed now? Thank you. Please invite the officials to join us. Since the last meeting, we have received from the administration a reply letter to the questions raised by our legal advisor, as well as questions raised by members in previous meetings. So let's deal with the two papers now. The first one is CB 4364 1415 bracket 01, and then we have to consider CB4 153 and CB4 292, a letter from our legal advisor and a reply letter to the legal advisor. I'd like to welcome the Deputy Secretary and also officials from the Intellectual Property Department. Let's have an introduction of CB4 364, liability with regard to films. At a previous meeting, Ms. Sid Ho raised a question about Cantonese films made in Hong Kong in the mid-20th century and the applicability of copyright protection for these films. As you have pointed out, Chairman, we have provided a paper setting out the response. In determining whether a certain act infringes copyright, we need to consider whether it is a copyright work, and if not, then it can be used in the public domain. We are concerned about copyrighted works and how is the duration calculated. So we set out the overview in paragraph 2 that even though the copyright exists, there's no infringement. For example, A, only the ideas of the underlying work have been incorporated, or only an insubstantial part of the underlying work has been incorporated, or C, the copyright has expired and then it's in the public domain. D, that the copyright owner has agreed to the use, and lastly, E, there are more than 60 permitted acts, and the use can be allowed and legal without the need of the copyright owner's consent. So if it's one of the permitted acts, it's exempted. As for duration of copyright in films, the date of production will be relevant. For example, 4A, in paragraph 4A, for film that was made between the 12th of December 1972 and 26th of June 1997, i.e. before the commencement of the copyright ordinance, its copyright subsists until the end of the period of 50 years from the end of calendar year which includes the date of its first publication. Secondly, for a film that was made before the 12th of December 1972, its copyright is not protected in the form of films. They were protected as original dramatic works or photographs, if they are photographs in respect of the film. In respect of original dramatic works, if the work is published during the lifetime of the author, its copyright subsists until the end of the period of 50 years from the end of the calendar year in which the author dies, so its life plus 50 years. If the work is published after the death of the author, then its copyright or photograph subsists until the end of the period of 50 years from the end of the calendar year in which it is first published. So for a film made in mid 20th century, is it a copyright work for which copyright has expired? We have to look at the actual circumstances of each case, and then we have to ascertain whether there's copyright subsisting in the film or the photograph concerned. Questions, members? Ms. Chen Yunhan.
剛才咧就政府做咗一啲解釋啦，我都想問一紮嘅解釋。
So the administration has offered us an explanation. You talk about last time actually. You talk about the 4 conditions on fair dealing, and also there was no such restriction on news reporting. Are you hindering the discretion to be exercised by the court? Are you on the same paper we are discussing? I think so. I don't think so. Let's deal with this paper first, okay? Mr. Dennis Kwok. I want to talk about the exemption for the parody. The paper, Mr. Kwok. Members, if you have no further follow-up question on this paper, let's complete the discussion of this paper. Are you talking about the reply letter? We are on paper 364.
主席啊，我以為我哋處理咗嗰個係。
I thought we are on 364. 1415 bracket 02. No, we are on bracket 01. Okay, so I would wait until we move on to 02. So if members have no further question on this one, we should move on. Ms. Mo, 2B. Only an insubstantial part of the underlying work has been incorporated. This is rather abstract. Insubstantial part. The 2 versions, the Chinese version doesn't really tally with the English version. So we're talking about an insubstantial part. In our existing provisions in the field of copyright protection, when we define an infringing act, one of the important elements is that it's the copy that you have made a substantial part. Under different circumstances, the part or the amount or the proportion is not defined, it's left to the court. It's a question of quality and quantity. You may not put a number to it or a percentage to it. If it's a song, then the secondary chorus may be an insubstantial part, but it may be the most valuable part of the song. So this would be taken into account. And then second, we'll look at the quantity and how much a proportion has been incorporated. So it's not a hard and fast rule that 51% is substantial, or if it's under 50%, it's not. It doesn't work like that. Each case would turn on its own circumstances, and we'll look at whether it's an important part or most important part, and the use of that part would mean that you don't have to buy the work, or is it the most important or valuable part? So it's a question that would turn on the quality and quantity of the use. Well, quantity is easy. Say 51%, you can easily calculate whether it is 51%. But if it's a quality, then the question will be left to the court. And the Chinese equivalent is 非实質 or insubstantial in English. Substantial to me sounds more about quantity than quality. How can you deal with this translation of the term?
I thank Ms. Mo for the question. In short, the concept of copyright has been in existence for over 100 years. There has been case losses and it's been codified. Well, I think the central idea is, well, if you copy something that is copyrighted, then it's an infringement. And as to what constitutes copy or what is a substantial part, there has been abundance of cases. When it comes to substantial part or insubstantial part, in the section 22 of the ordinance, there is already been decided. There has been case laws. So it depends on the case, whether it's a song, whether it is a book, and what the circumstance is, because it may apply to literary work, dramatic work, or songs, but that is the legal principle. Mr. Ray Chan. So when it comes to the quantity, just now Ms. Mo said 51%. Well, 51% counts because it's more than half. But what about case laws? Has it been decided that is the case? Because you don't just look at quantity or quality. So maybe it's like 15 minutes, 3 or 2. When it comes to Cantonese films, maybe there are about 20 songs, and if you take one song out of it, it may constitute infringement under 2B because it's a substantial part. Let me clarify. When I said 51%, that's only an example to illustrate my point. It's not the case that as soon as you've gone beyond 51%, then it's an infringement. As I said, when the court decides whether it's an infringement as a result of a substantial part being copied, it's not just. It doesn't just look at quantity, it will also consider quality, depending on the circumstance. Well, there has been a case law that the chorus, just a few bars of a song, constitutes the main part of the song. So if you look at quantity only, whether it's 1/3 or half, then it doesn't meet that requirement. So I think it is about the most important part, whether it's a part that will leave an impression, whether it's the essence of that piece of work, the importance. So it's not a percentage or a figure. So the quantity itself is not important, because whether it's a half a minute or a minute of the chorus, it may be the most important part. For Cantonese opera, maybe it's just the most prominent and well-remembered line. Can I understand it this way? According to case law, well, it's not just about the key part. For some pieces of work, maybe it is the bars of a chorus that stand out. But it's difficult to say which is the most important part. You will have to look at how much is taken out of the entirety. So it's about a weighting. And it's for the court to decide. And in all case laws, there is a balance struck between quantity and quality. Just now, the DSS said there has been a lot of case law. So can he quote some? Say 30 seconds of a Cantonese film constitute an infringement. So has there been some authority? I believe so. You supply the information to us afterwards? Yes, we will do it in a supplementary paper. Mr. Charles Mock. This is about Cantonese films. Well, I think it's because Hong Kong people are quite familiar with Cantonese films. And I think it's not just about whether it's Cantonese, Mandarin, or any language. If it's not made in Hong Kong, say a film, it's equally old. Say a Western film or Taiwanese film or a mainland film in that era. Maybe before the establishment of the People's Republic of China. So would that be the same treatment? Will it differ because of the source country? Say, for example, 50 years for some countries, say the US. In the past decade or so, it's been extended. It's 75 years after the death, not 50. And there is also resale. So after the death of the author, it may not be passed on to its family members. It might have been resold. Will someone say, well, you're safe in Hong Kong? But according to the US law, then you have committed an infringement and you will have to shoulder criminal liability in another country. Well, maybe you think that is Cantonese film is okay, but you are charged with the US law. When it comes to the period of protection of copyrighted work, it differs from country to country. We're here in Hong Kong, so we can only talk about Hong Kong, and we can only talk about the copyright protection in Hong Kong. If it's a U.S. copyrighted piece of work, if it's in Hong Kong, then a subject to a period of time that is the life of the author plus 50 years after his or her death. If it's in the U.S., and if it's 75 years, that is only an example because I don't know about the period in U.S. I know it's different from Hong Kong. And if it is, if there is still protected in the U.S., but the period has expired in Hong Kong, then in Hong Kong you can freely use that piece of work because it is in the public domain. If the U.S. owner wants to exercise its rights, then they will have to do it according to U.S. law that applies to the piece of work being used in the U.S. But you talk about YouTube, online websites, as you say in your document. They may not sue you in Hong Kong, but if it's on YouTube, then it's worldwide. Then the owner will use the law of another country to sue you. It may happen. This may happen to work that is beyond 50 years but still within 75 years. Indeed, in different countries there is a different protection regime. If the U.S. law is triggered, then the proceedings will have to be taken out in the U.S. In Hong Kong, then is subject to the Hong Kong regime. What about a Western movie in the U.S. is beyond 50 years but less than 75 years? If someone uses YouTube or a local platform to upload the film, maybe the owner cannot sue you in Hong Kong, but can the owner sue you in another country? Say, for example, have a summon issued to you? Is it possible? Well, it can be an old Western movie. Because if it applies to Cantonese films, it can apply to Western movies, Western films. But this question was raised by Ms. Ho, and we have this paper in answer to her question. Well, you are right in terms of the principle. But different copyrighted work is subject to different periods of protection in different countries. As a Hong Kong user, you will have to first understand the Hong Kong regime. Since the internet is boundaryless, we cannot rule out the possibility that the piece of work is still under protection in another country. Ms. Mo. This paper is titled Legal Liability of Uploading Copyrighted Cantonese Films Made in Hong Kong in the Mid-20th Century. Mr. Mok mentions about Western films. Well, so it's the same when it comes to Mandarin films. Say, for example, The Kingdom and the Beauty. So it applies, right? Yes. It's just that the member mentioned Cantonese films last time. And certain pieces were cited. And we replied to a question as a result. Well, the film I mentioned, The Kingdom and the Beauty, is before my generation, is their all-time favorite. I think it's my mom's time. It's my mom's favorite. It's the middle of the last century. It's in Mandarin. You mentioned that a part that leaves an impression. And you also said that it's for the court to decide. Well, but some people may think that it's the part where it rained, or it's the part when they break up, it's the part when they come back together. Maybe it's the part when they were flirting or teasing each other. And some people may say, well, when the man is leaving the woman, which part? Of course, it's subjective. It's subjective. No, it's very subjective. Of course, it generally is objective, but there is an element of subjectivity. When the court decides the case, maybe the court will take all the factors into account. Say, for example, which is and the substantial part, what is the use. All the factors will be balanced before a decision is made. And as to which is the most valuable part, which is the part that leaves the biggest impression, I think is a balancing exercise. Subjective and objective factors are taken into account. Mr. Ray Chan, you still have questions? Yes. I would like to ask paragraph 4, 4b, I, that is 1. Well, after the piece of work has been published and 50 years after the death of the author, and if it's published after the death of the author, then it's the end of the calendar year in which it's first published, and then add 50 years. If the author dies and in his belongings you find that piece of work and it's counted as published, or what? And if the family member stops the publication of that piece of work, does it mean that it's not published at all? When it comes to publish, it's about making it available to the public. And if it's found in the belongings of the deceased, then it is not counted as being published. We're talking about making it available or published in the public. If it's hidden in a corner of the drawer, then it's not published. And that the year is the year when it's published. Then who has the right? The surviving members. Who is the one who published it? The one who found it, or the administrator? Well, the one who inherits the estate will own the property.
Well, what if the person died intestate? Would it become public property? And then then the 50 years start to run? Well, in the copyright ordinance, we can only talk about the duration of copyright protection. As for how the estate is inherited, we have to look at the law on inheritance. Deputy Secretary, there are laws dealing with intestacy. We act according to the law on that. 4A. I've been trying to guess what it means, but I better ask my questions. Can you give us some examples? 4A, for film that was made between the 12th of December 1972 and the 26th of June 1997, i.e. before the commencement of the copyright ordinance, and so on and so forth. Its copyright subsists until the end of the period of 50 years from the end of calendar year, which includes the date of its first publication. And there's a footnote. Please clarify the years and the duration. Well, the local copyright ordinance was enacted in 1997. On the 26th of June 1997, well, the ordinance came into effect on the 27th of June 1997. For those before that, they will be covered by the UK Copyright Act 1956. So for the period before the ordinance came into effect, we have to look at the UK Copyright Act. What happened to those which were made between June and December 1997? Well, after the 26th of June 1997, we already had the copyright ordinance. We'll have to refer to the provisions in the ordinance. The member asking the questions did not specify the year. So we have to make a distinction here with regard to the year of production. I thought that our copyright ordinance came into effect in December 1997. Apparently, this is not right. It came into effect on the 27th of June 1997. Am I right? It was passed, and it commenced. It was passed in 1997. So can you also explain why this the date of 12th of December 1972 is so precise? Well, there were different Copyright Act. There was the Act of 1956, and there was a previous Act. So we follow the date provided in the relevant Act. If a film was made in October or published in November 1972, then what would happen? Then we have to look at 4B. 4B, B1, Roman 1. A film that was made before December 1972, so let's say 1971, we'll look at 4, bracket B, bracket Roman 1. It would be protected as original dramatic works. Then it's 50 years, life plus 50 years. Who's the author? Is the production house, say, Shaw's brother? Well, it's in the ordinance. And also in respect of film, is the script writer or the director or the composer of the musical scores. There are a number of important people. Please refer to Section 11 of the Copyright Ordinance, the existing Copyright Ordinance, Section 11.
關於一啲影片呢，佢又有講話就係嗰個製作人或者主要嘅導演咁樣，咁就計佢哋即係當中呢最長壽。
We look at the important people involved and among them who lives the longest, and then it's life plus 50 years. The new clause 18 would replace Section 39. I'd offer some comments. The government has not offered any comments, so I'd like to take them up now. Please wait. We're still dealing with this paper. If our no other members has any more comments to make, Mr. Mo, I want to clarify something here. It said that Cantonese film made in Hong Kong, but it's not relevant so far as the location is made. It's not about a particular jurisdiction, right? It's just that wherever I will be protected by local law on copyright protection. It's stated here that it's made in Hong Kong. I just want to clarify that it's not significant. Well, it's put there because the reference was about a locally made Cantonese film. Is that correct?
呢度咧，因為牽涉到咧就係有關因為牽涉到咧就係有關嗰個我哋頭先講咧。
Different laws gives different protections and for different works. If it's a foreign film, would the provisions be applicable? Well, at that time, we followed the UK law, and it was applied to Hong Kong. If it's another jurisdiction, we will have to look at the UK Act, whether there was a clear reference to those jurisdictions. Say, if the uploader doesn't know whether the film was made in Hong Kong or in Malaysia, that would make a difference, right? It's Cantonese film. I don't know whether there were Cantonese film made in Singapore at the time. We have to look at the works, the use of the work in Hong Kong. Well, Ms. Holt was referring to Hong Kong-made Cantonese film. I haven't checked the details, so I do not want to venture an answer. If you want details, I'll have to check. Well, I'm not asking for research. I just want to make sure that is different. I don't think you can look at the case for each and every jurisdiction around the world. And when someone makes a copy of a Cantonese film, is a recording of the TV program. And sometimes you can see the logo of the TV station, and sometimes even the commercials are recorded. So it was shown on the TV station on a certain date, and it must be a recent date, assuming that is a video recording. Does the station owns any right? What about the commercials, the advertisements? If a work is the subject of a broadcast, then it's a work, a copyright work, and there's also an underlying work. Say, if it's a TV drama productions, there's a script and it's protected as dramatic works. So the TV station enjoys copyright protection with respect to the program, but there might be literary works or musical works which are underlying works and which are protected. So for a piece of work or a program, the copyright protection will apply in different ways. Well, in my example, the TV station purchased the Cantonese film, and the film is shown. I know that there are different copyright protections for the script and for the musical work. We're now talking about the black and white Cantonese films shown during small hours, and is broadcast with the TV station logo shown in the corner. And if it's recorded and uploaded, well, yes, advertisement enjoy copyright. What about the logo itself? Is there any right subsisting in the logo? According to Section 2 of the Copyright Ordinance, different works may have different copyrights. Broadcasting itself is a copyright. So the TV station enjoys copyright in respect of the broadcast, there are two possibilities why the Cantonese film can be shown. Either the TV station is the owner, it owns the copyright of the films. So it's both the copyright owner and also the broadcaster. Second, it's done under license. The copyright owner grants a license for the Cantonese film to be shown, to be broadcast. The original copyright owner, of course, owns the copyright. So there's one further party to the case. So simply put, a broadcast is also relevant for copyright. Say, is something that happened in 2003, 2005, that is recently. So we can put aside the question of 50 years. So the film was broadcast in 2005. The logo of the TV station was shown, and if someone uploads a copy of that, the TV station may lodge a claim, right? Well, if the Cantonese films are purchased, then we'll count the original publication. We'll have to look at whether this is granted as a license or as an outright assignment. We would look at the original production, the original publication, and counts 50 years. And if it's sold to the TV station after the publication, then the duration will be shorter.
Say, for example, if it's broadcast in 2005, Mr. Wong just now talked about the broadcasting right, or ownership of the copyright. Are you talking about a different right? So the copyright of the broadcast has been violated when I show something that I have recorded. Maybe, perhaps the Cantonese film itself is just decades old, but I recorded it from a television station, so I have infringed the copyright of the television station. If you look at the broadcast or a cable program, then it's a separate one. So I haven't infringed the original copyright, but I have infringed the copyright of the broadcasting of the television station. Yeah. Mr. Potter, Mr. Mog reminds me of a point about overseas work. And sometimes these overseas works are transacted in Hong Kong or shown in Hong Kong. Yes, in the past we used a 1956 Copyright Act. We have to take into consideration domicile, whether it is related to the UK owner before we can invoke the copyright ordinance. There are countries that have no relationship with the UK, and in Hong Kong their copyright regime were not recognized. Say, for example, some Danish painting on bricks. I learned about it when I was a student, but it's been a very long time. Please enlighten me. Yes, there is the idea, the concept of a domicile. That's why I said it's related to Hong Kong, because we are linked with the 1956 and 1911 Acts. There has been expressed provisions about the about where the author domicile. So, in short, your understanding is right. A follow-up question. So we still use the 1911 and 1956 UK Act. We have to look at the place of the domicile. What about after the reunification? When it comes to domicile requirement, it's not as strict as before. It's protected whether it is in Hong Kong or overseas countries. So overseas owners, if their work is used in Hong Kong or published in Hong Kong, then they are protected by the Hong Kong law, wherever the author domiciles. Right. Ms. Mo, I've been talking to Mr. Mok and Mr. Ray Chan. Domicile is a legal term. So what is it in Chinese? It's the premises or place of a registered address. It doesn't really make sense. In answer to Mr. Mok's question, say an old film, the rights been sold to television station, so the television station owns the copyright. You gave an answer. Now my question is that my understanding is that when it comes to these old films, once they have been sold to television stations, they have been sold completely off. There won't be a remaining 20 or 30% of the copyright. Say if it's sold, then it's an agreement between the film, the production company, and the television station. You did not even mention the studio. You mentioned about the director, the choreographer. So I'm confused. Who are you talking about? If it's an old film, it's been sold off, then I have to liaise with the television station if I upload it. But you also say that when it comes to the original author, if the songwriter is still alive, then it's 50 years in relation to him. So there is double jeopardy, isn't it? Well, what is sold is the remaining years of the copyright protection period. That is 50 years after the death of the author. So, well, when you calculate the time is in relation to the author, but when it's sold is in relation to the remaining years of the protection period. But the film company is not a natural person. It's not a person. They won't die. Well, unless it's closed down. I wasn't clear, sorry. Mr. Jones said, according to Section 11, when it comes to films, it refers to the producer or the main director. So it's a natural person who will die. When it comes to the copyright owner, it may be a body corporate, a company. So they are two different ideas. It's very confusing. Well, people may think, well, it's an artist who has written a song, and the songs have been sold to the film company, and the film company will own the copyright of the songs, whether the songwriter is alive or not. Say it's a songwriter. The person will be the first person who owns these songs. If I am the songwriter, I can sell the songs. And what is sold is the copyright of the songs. That is my lifetime and 50 years after my death. When I'm sold, and when the buyer gauge the price, then it will gauge on the understanding that it will be my lifetime plus 50 years. The ownership is not indefinite. It depends on on when the author dies. If I die young, then the period will be shorter. Am I right to say this? With the example you cited, you're talking about two copyrights. One is the songwriter who have sold the songs to the production company. When the production company makes it into a film, there will be a separate copyright. So there are two copyrights here. Say, for example, karaoke will be sold by IFBI and the song. IFBI is in relation to the album. The cash is the songwriter. Am I right? Yes, perfect. Perfectly right. I thank you for your explanation. There are different levels of copyright protection. Mr. Zhe explained that, say, it's an author. It may be turned into a playwright. Then is the lifetime of the author plus 50 years. And if it's made into a film, then is the copyright of the film, not a piece of literary work. So it's a new separate copyrighted work. So the time will be from when it's published plus 50 years. It's complicated because there are different levels. If you separate the copyright of the different work, then you will understand the period when they're under protection. Sorry, the speaker's off mic. Let me ask. So for the same film, when there are problems with the copyright, I may be charged with different offenses, different charges when you trace the work to different levels. Let me explain in this way. It depends on how many different copyrights is involved. If it's a piece of if it's a song, if it's an audio recording, and there will be the song itself, the lyrics protected under music, under literary work, and also the recording, free copyrights. So it depends on how many copyrighted work is involved. Different copyright owners are protected under the law, and they may take actions respectively. Is it clear, Mr. Ray Chan? I would like to talk about Cantonese films, because this document is about Cantonese films. It's not a hypothetical question. Now, TVB said they would like to buy the 700 plus Cantonese films copyright. ATV refused, and ATV just want to sell the broadcasting right. If there are two copyrights here, if I use the work, so I will be charged with 2 counts. Is that right? I did not sell it. I just hold it. Then it's then is 1 count. If that work is sold to TVB, then there are 2 counts. When it comes to copyright, the broadcasting right is a right to use it. Well, maybe the contract states that the television station may broadcast it in this period. If a third party show the film, say it's a recording is shown, the recording is shown. Broadcasting is itself is copyright. if there is illegal recording, then it's an infringement. Well, that the broadcasting is the broadcasting of a piece of copyrighted work. License is given for the television station to show it, but not to you. So we're talking about two different copyrighted works. So if I'm ATV, I sell it to 9 television stations, and then I make a recording and show it, so I will be charged with 9 counts. Mr. Ma Fong Kwok, you raise your hand. You would like to ask follow-up questions? Well, if there are no other questions, let's go into bracket 02. Just now, Mr. Dennis Kwok raised his hands. Mr. Kwok, thank you. My point of concern is page 4, question 19, question 13 clause 19 about the UK Act. There is a provision limiting private contractual terms to limit certain acts. This is in relation to fair dealing of parody. The letter said that UK is the only country that adopts this approach, and when it was scrutinized, it was quite controversial. I dug up the record. It's the 29th of July 2014. The House of Lords explained why the UK government deemed it fit to propose a provision that will nullify or overriding private contracts. Say Facebook and Sony Pictures, there is an agreement between them that when something is used on their website, they cannot make use of the exemption on parody under the Hong Kong regime. Facebook cannot, users of Facebook cannot rely on parody exemption provision.
If big corporations have come to such private agreements limiting or overriding the protection offered in the ordinance, then that exception or protection will become meaningless. Therefore, in the UK Act, it's stipulated that the private contract terms cannot override the statutory protection. It said it's controversial in the UK. I don't think it's really controversial. It's overstated. So it boils down to the question as regards who you want to protect more, the copyright owner or the user. If they think that it's more important to provide an exception for parody, you should do it to the fullest extent. You should have this provision so that we won't have a situation whereby big corporations can come to some private contracts rendering the protection meaningless. Ms. John, according to the example quoted by Mr. Kwok, if there are private contracts between Sony Pictures and Facebook saying that they will not allow such exemptions, would it mean that users in Hong Kong will not be protected or accepted? Well, the exception in our copyright ordinance would mean that such acts will not be infringement of copyright. But the contract between Facebook and Sony Pictures is a private contract, a civil contract. And because of the privity of contract, users are not going to be affected. The contract subsists between Facebook and Sony Pictures. So we can look at it from two ways. In the copyright ordinance, we allows the user to be exempted from the copyright infringement liabilities. So we can still offer the protection, but that's not meaningful. If there's a contract between Facebook and Sony Pictures, if I post or upload a picture, a parody picture, Facebook will say that this is not allowed. This is not allowed by Facebook because it violates the posting rule of Facebook. Because if there's an agreement between Facebook and Sony Pictures overriding the legal exemptions in the law, yes, the user will not be sued, but in reality, the posted photo will be deleted by Facebook. We allow parody because we want people to be freely expressing their views through parody. So if you want to offer the protection, you should offer this equivalent provision in the UK, so that the freedom of expression of the user will not be affected. We have this principle of privacy of contract, or privity of contract. If it's a contract between private parties, well, they are free to enter into contract. That's the freedom they enjoy. Because through a contract, the economic benefits can be fully reflected. We have to respect the right of doing this. If it's something between Facebook and Sony Pictures, and what will be allowed in this platform, and maybe it would include the exclusion of parody works, because they will have to consider this in the calculation of the license fees. Is it reasonable then to limit this through a piece of legislation? The platform and the user are also in a contractual relationship between two private parties. So you may have a contract between the user and the platform, and another contract between the platform and a third party. Should we be dealing with this through this kind of relationship through a law? Well, very often the platform would operate in accordance with the U.S. law. Let me supplement. This is important, Chairman. You talk about the freedom to enter into contracts. So are you saying that the UK will not have this freedom if they have this stipulation in the UK Act? There are statutory overriding provisions found in other laws, and that is you do not allow a private contractual term to be in conflict with a statutory provision. That's common. Why do we have to have this in moving the Act in the House of Lords, they have this explanation.
Right clause gives users, consumers, and business certainty and clarity that the exceptions apply in all circumstances, regardless of the detail of a contract. Without such clauses, restrictive contract terms could prevent the uses permitted by the exceptions, thus preventing benefits from being realized. 呢個就係正正頭先我所講嘅問題。
Well, this is the problem that I have talked about. If there are big businesses which have entered into contracts with such provisions, contractual terms, which mean that in essence, in reality, the user will not be protected by the exception for parity, then the exception is superficial, because I will be prevented from uploading the parody work in Facebook or YouTube. This is not allowed by YouTube because of the contracts entered into between YouTube and other big corporations. And because of such private contractual terms, the user will be in actual terms restricted, and they cannot really rely on the exception to actually achieve the spirit behind the exception. Well, I think it's just like the restriction of some private clubs not allowing the patrons to enter if they wear jeans. I don't think that's the right way to compare the cases. But these vehicles or platforms may not be accessible to all those who would like to invoke the exception for parody. If it's just Sony Pictures and Facebooks, then maybe there are other platforms or channels. Chairman, I don't think you need to summarize my comments. I'm sure you don't understand what I'm talking about. Mr. Wong, the Deputy Secretary, understands what I'm talking about. I hope you can reconsider the case. Thank you, Mr. Kwok. I think Mr. Kwok has referred to the public policy behind the stipulation exception in the UK Act. We are of course mindful of the developments in other jurisdictions. We have made reference to the copyright legislation in other jurisdictions, UK being one of them. In respect of parody, UK is the only jurisdiction doing this. Of course, there are public policy reasons behind that. Other jurisdictions such as Canada and Australia, they also have people doing parody, but they don't have a statutory provision overriding arrangements made through private contracts. There are, of course, public policy, the reasons behind that option. There was an Australian study many years ago, but so far in Australia, they have not moved any legislative amendments to change the common law position on this. I understand that the point about public policy considerations. Yes, ultimately this is a public policy consideration where the line should be drawn. I hope you will understand that Hong Kong is a small market. We are not a country. If the big corporations enter into such contracts with such contractual terms, it would affect the operation of this piece of local legislation. Sorry, I haven't finished. We understand the public policy grounds and considerations. But should we just look at parody? There are more than 60 exceptions or permitted acts or uses without the need to get the consent of the copyright owner. We have to be careful that if we do this, should we have different levels of protection? And that is for parody, we would offer a statutory exception or overriding provision. Should we be doing this for some or all of the exceptions? As we have indicated to the Bills Committee, we would monitor the developments in other jurisdictions, and we may have to make sure that we always have a good public policy grounds to rely on. And the current proposal is the result of making reference to other jurisdictions and the reasons behind the different options or stances adopted. Copyright is part of the IP law, it's not part of the contract law. Here we are talking about the freedom to use copyright work by a third party without the backing of a contract. But the other rights to make a claim or to proceed with litigation will not be affected by this exception or protection. The UK has this stipulation that private contract terms should not or cannot override or limit the exception. What are the public policy grounds? Is it that Facebook can come up with something that will override our copyright ordinance? If you open an account with Facebook, you are asked to accept their terms, and that is we don't offer any exception for parody or the caricature, and then the exception will be nullified once we agree to open an account on that basis. I think Mr. Kwok has made it very clear how the UK officials respond to the questions on the stipulation.
Well, when it comes to the amendment of the UK Act, it's a result of the Hargreaves review. As Mr. Kwok said, maybe it's for certainty of contracts. But will it bring certainty? In our case, there are comments saying that it not necessarily. The second point is that some platforms allow users to upload things, and the platform is a private enterprise. I am the user. Maybe I use the platform subject to conditions. And as to whether there are other agreements with copyright owners, it's a separate matter. If he sets up a platform, then he has the duty to make sure that everything is in order. You talk about YouTube, Facebook. I cannot say for sure, but our understanding is that when it comes to US-based multi-country platform, it may operate on US laws. Mr. Charles Mock. Mr. Wong mentions about jurisdictions. Is that one of the reasons why you are concerned about contradictions? I agree with Mr. Dennis Kwok. It's not just about Facebook and Sony. Facebook itself has imposed conditions when it's say a local production house. May on a DVD or when it's being broadcast showed a condition saying that you can't even use it for parody. Well, it seems that the UK approach is reasonable because you don't want to cause confusion for users. because users naturally don't know. And as to overriding provisions, say media shifting is about this. Say it's a music, it's a piece of music, and the terms are quite harsh. You can't change it to MP3 or whatever. But if you use it but it's for your own use, then you're allowed. So there are overriding provisions. But for this, you choose not to adopt it. Why? Because of what you said? Law enforcement, cross-country. As we've said at the outset, different countries different. Do you have to avoid this because of this reason? And you don't adopt the UK practice? I thank Mr. Mok for giving me another chance to explain it. As the paper suggests, there are provisions giving exemptions, over 60 provisions. There is no need for us to make an additional provision to state, well, under what circumstances contract override is not allowed. But there is no contract override provision that results in a user not being able to use exemptions. Users can still have exemptions. So the example cited, say by Mr. Ray Chan, they won't happen. It's difficult for me to comment on hypothetical example. Maybe for Facebook, it operates on US laws. It's a different area. I'm talking about the principle. When it comes to the copyright regime, it's by statute law. There are recognized principles that there is the property right. The author will have the copyright, is respect of the author and the respect of his economic rights. But for economic reasons, we allow exemptions. But it should be supported by sound public policy. These are the common principles adopted by different countries, say for education, for commenting. In general, countries won't get involved with the contractual regime, the contract law regime. If entities enter into the contract to restrict their behavior, they have the freedom to do so. The terms will reflect the value. Do we need another provision to override this freedom? So far, only UK adopts this approach. But we don't see a blanket application. We don't follow a forerunner. We follow the international trend. We don't see that, and we don't see cases when the users are limited in using the piece of work. But we will monitor the international trend. We will follow that up. But on the caution side, we should follow a well-established and practiced approach. There is also exemption of public interest. that if there is significant public interest, if it's of significant public interest, is not subject to the copyright control. I would like to follow this up. Mr. Kwok mentions two enterprises. It's a private contract. I'm a user, and I have an agreement with Facebook when I use it. Say a film company says, "Oh, you cannot use this film for this and that." Would that be a contract in its own? So whether it's public interest or what, does it mean that that term will be nullified? Will be null? Well, there is an agreement between me and Facebook. Very often what we see that is an agreement that restricts the behavior or the acts of the contract parties. When you're just a general user, if you're using a platform, there may be some restrictions. When the platform accepts your use, say uploading a piece of work, then it has the responsibility because it allows you to use the platform, and it's a completely different set of considerations. Ms. Sin Ho, sorry, it's the clash of meetings. I apologize. But I have to ask about films made in the 50s. Well, you have to wait then. You have to wait. We spent an hour on that. Okay, for this paper, I have a question. Question 10, Clause 18. Page 4. The administration will consider a CSA, that is, the performance, exhibition, playing, or showing of the work to the public will be revised to in public. Mr. Wong, you think the amendment would address the issue we put forward last time? Of course, we welcome the amendment, but will it be sufficient to address our concern? Thank you. We're asked by the Secretariat to respond to your point, and we will do it. This is a better drafting, a better way of drafting. Who is to take this question? Let me try to explain. This is a clearer way of drafting. It's to the public. It should be in public. And it's in public. In Chinese, 公開表演. It's better and more consistent. We think this is more consistent in meaning. But last time we said that because of playing or showing, if it involves the use of electronic means to make it available to the public, I think this question is not yet answered. So this is in response to a different point raised by the legal advisor, Mr. Porter. I thank Mr. Kwok for his work in digging up the debate in the House of Lords. Well, from the officials' understanding, apart from the agreement between Facebook and Sony, are there any other large providers or vehicles that have a similar agreement? Is it prevalent? Let me clarify first. We don't have that understanding. It's a hypothetical question raised by someone. If it's an assumption, then our concern may not be as real. Maybe there are actual agreements in existence. And you also mentioned about protection of content industry. The economic impact on the content industry. And you also mentioned about jurisdiction. I have not read the debate, the record of the debate. When you chose not to use the UK approach, did you get a good understanding of the arguments of both sides? If so, can you give me more information to help us decide?
I understand that before and after 1997, we are more inclined, well, I want to be objective, we are more inclined to protect the content industry. It's a tug of war between the developed countries with more established content industry and other users. It's always controversial wherever you draw the line. So what should be done for Hong Kong? We need to make a decision. So could you tell us more? But it's also about the bargaining power we have on different platforms. We can use WeChat, Twitter, if we can't use Facebook. It's just like what we are facing. If we can say whatever we want, but if we want our comments to be carried by radio or newspaper, we have to consider other factors. Well, I think this is also a hypothetical example. Major platforms operate in such a way that they would keep agreements with major corporations secret, confidential, because there are a lot of backdoor negotiations and legal considerations. Many platforms are operated in the U.S. and they act under the U.S. law. One of the important exceptions in the law is, of course, fair use, fair dealing. There's no contract override stipulation in the U.S. As for the pros and cons, well, we have looked at them very carefully. In drafting the bill, there was the consultation exercise. We also monitor the developments in other jurisdictions. We have been doing this in respect of the UK Acts and also the copyright legislation in other jurisdictions. As I've said, Australia has been doing studies over the years, and so far in Australia, there's no contract override in the copyright regime. So, having considered the pros and cons at this point in Hong Kong, we considered it not necessary to do it in Hong Kong. The platforms we have to consider is the legal liabilities, economic interests, and the contracts they have entered into with other parties. When it comes to a copyright legislation or infringement act, can a user use the copyright work in certain manners without the fear of being sued? Well, I believe that the protection we offer is good enough for the user. But can we be given more information, background information, if you don't have to devote a lot of resources into a research? Perhaps you can tell us the pros and cons, the different reasons why the UK allows this, but the Australian doesn't. I can certainly provide a supplementary paper. So you don't know for fact that there are contracts or enter into between the big corporations and platforms not allowing the user-generated contents. We have not discovered that there are such contractual terms imposing the limitations. As Mr. Wong has said, we have more than 60 provisions which offer some exceptions, and they have been in operation since 1997, and we haven't discovered that such exceptions have been limited through private contracts to the detriment of copyright works users. The UK might have considered the circumstances which are different from us. There was a study, there were consultation exercises. They may have to address specific questions that they face. And in response to Mr. Chair's questions, I acknowledge that there are divergent views, pros and cons. Yes, something was said in the House of Lords. I can also say that after the passage of the Act, different voices have been expressed by the industry, by authors and relevant professionals, and the academia. There have been opposing views expressed by these people. It seems that they think that the UK government has underestimated the adverse impact on the industry through such a liberal exception. And the UK government has also promised to conduct regular reviews. Since there are so much reservation and so many controversies after it was introduced through major studies and years of exploration, I think we should be more prudent in following suit. I have referred to one viewpoint expressed in the debate in the UK. If there's a contract between Sony Pictures and Facebook imposing the limitations, the contract override, then in using Facebook, I would not have the protection offered by the exception on parody. I think Mr. Wong understands my point. Second, there's a contract between Facebook and the user. It can add a provision that the exception for parody under our copyright ordinance will not be applicable. If Facebook and Sony Pictures sign a contract to that effect, and I as a user of Facebook, I will be barred from using that exception or using the protection afforded by the copyright ordinance, and then it would become apparent that that different platforms may have different rules. So I may upload this on Twitter but not on Facebook, and therefore the House of Lords says
people are able to rely on that law without having to work out whether there is a contract term to the contrary, creating a whole patchwork of different legal situations. Creating a whole patchwork of different legal situations. 呢個就係另外一個關鍵點啦。
That's crucial. Without such a provision, then sometimes I can do this on Facebook, but not on another platform because they have different contract terms. Then the meaning of the protection will be lost, because you provide this to make sure that there is full freedom of expression, but in actual situations, it's not accessible, it's not afforded, then the meaning is lost. I thank Mr. Kwok for raising this. Yes, we have looked into this and considered the case, actually. We are going to give an account of the reasons both for and against going down that route. Referring to Mr. Kwok's reference to the discussion, we have to look at the copyright ordinance as a kind of tort law, because we should not allow people to use a copyright work without the consent of the copyright owner. We provide exceptions that certain uses will be permitted, but it doesn't mean that under other laws, well, you are free to do whatever you want, because there are other laws and there are other legal principles which may apply. Say fiction. I want to make a film based on a fiction, and then there's an agreement between the author and the film production studio. In the contract, there may be certain restrictions. Say, I only allow the script to be like this. I have to check before you can only do this. And if there's a contract override and you can do something in the form of a parody, that would be a serious erosion of the author's right to enter into a contract. So in Mr. Kwok's example, different platforms may have different rules, but we also have to consider the different economic interests involved in different circumstances. Well, you provide the exception for parody, for user-generated content, then such a situation may arise. You can't say that I protect your right, I allow an exception for parody, but the exception for parody will not apply in certain circumstances. It's either you give the protection, the exception, or you don't. The purpose of giving the exception is to protect freedom of expression. This exception is good, but without these additional provisions, it would just backfire despite the good intention. Mr. Ma from Kwok, from speaking from the perspective of the content industry, of course, that they will try to be outside the scope of the exception. Using the example used by Mr. Kuo, say it's something between Sony Pictures and Facebook. There's a contract between the two. The contract is made or entered into for the purpose of making a profit, and the end user has no right to make any profit out of the use. If it's for the purpose of parody, the exception is there, it's okay. The Facebook has no right in the first place to restrict the user, even if you have something written down in the user's guidelines that it cannot be used for commercial or for business. The user can use it as a parody. And if the contract between the two parties are between the two parties is for the purpose of profit, it should not affect a third party. Is my understanding correct?
如果或者要一個即係喺原則上面嗰個解説咧，就係
Let's start from the underlying principle. When it comes to the enforcement of the contract or the discharge of the contract, is of course between the contract parties. We provide a copyright exception. The user will be afforded protection. He will not be sued for copyright infringement or civil liabilities. But if it's another private contract entered into freely, then it's within the realm of the contract law.
Well, if the terms applies to another party, there should be an agreement between the two, and as to whether the terms are reasonable and whether the agreement is valid, then you have to understand it from the perspective of contract law. Mr. Ma. I think the spirit of the agreement itself is sufficient to limit certain acts. If the act is not done in accordance with the law, then it simply should not be allowed to be done. Well, the administration said that there are other provisions. I think there is no need to have this written into the law, that is to restrict the terms of the agreement. Am I right? There may not be any provisions to disallow someone using the terms to impose a limitation, but it doesn't mean that these terms can be enforced, because you will have to consider whether the terms are reasonable. I think it's a matter for the market. Say Facebook had an agreement with Sony, but Facebook did not say clearly that an agreement should be signed with other movie companies. Maybe Facebook needs Sony to supply them with certain products because it's a huge film company. If Facebook said that no copyrighted works of any films should be uploaded, maybe it will draw more attention. Mr. Zhang, I don't really follow Mr. Ma. he talking about the copyright owner and the consumer using the copyrighted work, an agreement between them, or are we talking about Sony and Facebook? It's not about the contractual relationship between the platform and the user. Well, Facebook has this agreement with Sony, does it mean that there is one less platform for users to use copyrighted material in their parody? Am I right, Mr. Ma? Or don't ask me. I think, well, you are cross-purpose. You're at cross-purpose. Mr. Ma? I just want to know, when a user uses a clip from Facebook in parody or pastiche, not for profit, when it's not done for profit, then no matter what agreement is signed with Facebook, there won't be any criminal or civil liability. Is that right? Because the law says that when it's used in parody or pastiche, there is an exemption. If there is a creation in the pastiche or parody and profit is generated, then it's a commercial activity and it will be seen as a breach of the law. Am I right? Well, may I allow to clarify? Mr. Ma's point is the contractual relationship between users and Facebook. But this morning we were talking about platform and content suppliers. If there is an agreement between them, then it will affect the choice of platform for Hong Kong users to upload their parody work. Well, is there a response from the administration? Yes. Let me say again that copyright is a form of tort. Well, we're talking about what are the permitted acts without the consent of the owner. Copyright is a branch. Well, there's a freedom in reaching an agreement based on the economic benefit. It says that in this part, for some copyrighted works, so there will be permitted acts in the use of these copyrighted works, and this is in relation only to copyright infringement. It does not apply to any other obligations and rights outside the copyright regime. There are 3 members who would like to ask questions. Ray Chan, Charles Mock, Sid Hall. We'll end at 1:45. Please be brief. Mr. Chan? Thank you. Well, if it's like what Mr. Ma said, for profit, then you're caught. Then it will be a lot easier. It seems that we get bogged down here for quite some time. Because we want to clarify the provisions in relation to exemptions related to parody and pastiche. If the terms of a contract can override the exemption provisions, that means there is no exemption. No exemption from civil liabilities. Well, if the terms are unreasonable, of course we can have them quashed on the point of public interest. So has there been any authority that public interest is used to nullify unreasonable terms in a private contract? And fair use and fair dealing, what is the difference? Say, if you have to follow the UK practice, does it mean that the industry will not support this bill? They may think that the power may be too much, that it will hurt some people. I'll ask the other two members to ask the questions first before we hear an answer. Mr. Mock, this is important. Mr. Tse asked, said that no one knows the terms of a private contract. That is true. It's not a hypothetical question. And it was said that there has been a discussion in the consultation. But to be honest, this is a minute detail. Discussion wasn't enough. Please give us more information. We have to come back to this point. Mr. Dennis Kwok has left his seat. I don't think he is happy with the answer. Ms. Ho, I thank Mr. Kwok for giving us the information. I would ask the Secretariat to get the verbatim record. Just give us a link. If it's applied by the Secretariat, then members will feel that is fair. I agree with what Mr. Ray Chen said. If it's not profit, then there will be an exemption. It will be a lot simpler. Mr. Ma should be on our side. I would like to hear an explanation. If private contract can override the exemptions, then we can only use the unconscionable contract ordinance. But from what I know, it's the most well-known case is the disclaimer on the back of the receipt of a dry cleaning shop. So how many case laws has there been under the unconscionable contract ordinance to protect consumers? Is this piece of ordinance sufficient to protect users using copyrighted works in parody and pastiche? And if there is no regulation of private contracts, does it mean that the entire bill has no power? I will let members who have not spoken to speak first. Well, we've been talking about CB bracket 4364 bracket 01 and 02. In a meeting on the 6th, I asked two questions. And in the paper 375, it's a Secretariat paper. There are two parts. There are three things for the consideration of the administration. Two of them are raised by me. I have some supplementary information. That is the drafting of 39(2)(c I've decided to move a CSA. If you don't change it, I can easily make 10 amendments. And 39 bracket 3, the Chinese word 斗 as in report. There are over 10 provisions with this word. I will move CSAs if you do not accept my proposal. You have not responded to this. And it's clearly stated in the Secretariat paper. Maybe you'll answer me next time. And we've spent 2 hours on the 2 papers. It's very constructive. Well, some people are confused. I have no idea what Mr. Ma Fong Kwok was saying. Well, you've heard the discussion for 2 hours. You've heard questions raised. Please give us a response paper. We're only at clause 19. Netizens are very concerned about this part, so we should spend more time to discuss it. Ms. Chen Yun-han, there are 3 meetings, and I am the deputy chairman of 1. That's why I have to go back into. Well, we're talking about 364 bracket 02. According to the administration's answer, it gives more room for the court. Where are you? That is in relation to the lack of definition of caricature, pastiche, and parody. And it gives the court room. I want to ask the administration, how do you see it? DS, you will just give an answer in one go. Thank you. Thank you for the question.
First of all, contract. I cannot say in the law the one thing overrides another. For example, the contract overrides the statutory exception. Very often an act is regulated or restricted by different laws. Copyright is about tort. It's about protection the property right of the copyright owner. Other people cannot use the work without consent, but there are exceptions, and that's what copyright law is about. But contract is a different thing. It's something entered into by 2 parties exercising the right to enter into contracts. The protection, the exception, is under the copyright ordinance. I don't think that if we do not provide for the override provision, then the protection is meaningless. I cannot agree. There are more than 60 permitted acts or exceptions. Other jurisdictions are providing similar things. The system, the regime has been working smoothly. Some members have asked us to set out in detail the arguments on both sides. In different jurisdictions. Well, we also feel that duty bound to offer further explanations. We agree. We are going to do this in writing, so people can have a discussion based on the same set of facts. We would try to find the reference background information. As for the questions raised by Mr. Wong Yuk-man, we have not been able to provide a response this time, but we are going to do this later in writing. And also for Ms. Chen Yun-han's question about the lack of a definition for these terms. We are saying that it should be left to the court because it would be a better protection for the user. Other jurisdictions are adopting the same position, and that is we should leave more space to the court. And under the common law, the interpretation of such terms can offer better protection. But of course, the user would like to get something even better. For the parody, satire, caricature, and pastiche, you are not trying to restrict the meaning here so that the court has a bigger room to maneuver. Well, for different users, even intermediaries, they think that it's better that we don't provide any definition. Members, so today we have dealt with the two papers before last. Lastly, I have to ask the legal advisor what she would have to say about the government's replies. Yeah, I do have some comments. I would let you know when we proceed to the cross-by-cross examination. Well, we have reached the end of our meeting. The next meeting will be held on the 3rd of February at 4:30. And then for meetings scheduled for March and beyond, there's a timetable for members on the 12th of March. I don't think we can make it for that meeting scheduled for the 12th of March. We may have to advance that meeting by a week. There's a meeting on the 23rd of February. Do we have a meeting on the 23rd of February? I'm concerned about the possible lack of a quorum. Well, if we are concerned, that is too much of a squeeze, we can also postpone it. So let's just slot it for the timetable. I will try to make some arrangement with the clerk. So, DS, are you in the know about this? Thank you.